You're missing some questions.
We're not up yet.
You're missing some questions, though.
You're now watching WLBT's Ask the Experts. I'm Kelly Boyd. Joining me today is attorney Ronald Morton from Morton Law Firm. Welcome back.
Thanks for having me, Kelly.
Yep. Happy Valentine's Day.
Happy Valentine's to you.
Happy Valentine's to you all. Let us know how you're celebrating. Today we're going to talk about qualifying for Medicaid related to paying for nursing home care.
That's right.
Right? And those questions come from our Ask the Experts page on WLBT.com, but you're certainly welcome to ask your questions to Attorney Morton while we're live. Okay. So very first question, if someone already has Medicare, why would they want or need to qualify for Medicaid?
Well, Kelly, it goes back to the basics behind why we even have these programs. So the Medicare program is health care for the aged, people 65 and over or the disabled. Mm-hmm. And to get Medicare, you've got to pay into the system. So that dreaded FICA tax that we see coming out of our check every week or 2 weeks, that's what that's going to pay for. Mm-hmm. So you don't get anything out of it now, but when you turn 65, you get health care.
You're paying in.
You're paying into Medicare. Right now, we don't have Medicare for all, but we have Medicare for people 65 and over if you worked. It is what we call an entitlement, meaning you pay into the system, you are entitled to it by law. Mm-hmm. And so it's basically insurance, so to speak, to cover you at your age, at the point in life where you're not able to work or not able to work as much. Okay. The Medicaid system, on the other hand, is a social safety net. It basically only covers people that can't pay for their own care. And the reason that people may need to think about qualifying for Medicaid rather than qualifying for Medicare or receiving the Medicare system in addition to Medicaid is because Medicare doesn't cover the same things that Medicaid does. And our topic today of paying for nursing home care, that's one of those things. In other words, Medicaid will pay for nursing home care, Medicare will not.
Okay.
And so you have to do planning ahead, or your assets already fit in the categories of qualifying for Medicaid if you're going to get that nursing home care paid for. Now, if you're wealthy and want to pay for it yourself, you can do that. But for everyone else, you have to either plan ahead or spend all your money. And then once you spend all the money, then of course you would qualify for Medicaid. So that's why people need to think about both, because they cover different things. We have a dual system in this country for our health care.
Okay. And I want to bring up your book since we were just talking about that. It's called Don't Go Broke in a Nursing Home.
Yeah, I do have a book on this topic, Don't Go Broke in a Nursing Home. And we actually have, this is actually an older version, we actually have a few of these left. And so I felt like if some of the viewers were interested in seeing that or receiving a copy, I'd be glad to send them a copy of that. I've also got some copies of our To Live and Die in Dixie book that are also available. And so we're finishing out both of these editions. If you're interested in that, you can call my office at 601 Elder Law and just request a copy. We'll be glad to send those to you. Or if you want to text the word Dixie to 601-600-2662, then you can download a copy. You'll receive electronic copy, and we mail those hard copies to you as well if you order those. So we have multiple ways for you to get access to those. They are in limited supply. So if you are interested, I think we probably have 10 or 15 of these left.
So act now.
Act now for this special one-time offer, right?
So they can call your office, 601 Elder Law, or text Dixie to, what was that number? I'll type it in the comments.
Oh, to 601-600-2662.
2662. So about 10 copies left, so act now if you want.
That's right.
All right. Next question is, how much does a nursing home cost?
Well, the average cost of a nursing home in Mississippi is said by Medicaid to be $6,853, I believe, per month. And so, $75,000, $80,000 a year. Some I see a little less than that. Most I see in the Jackson metro area considerably higher than that. So
is that all inclusive? Is that board?
That's your rate. So that's room and board. It's food. It's personal items and things of that nature. Okay. So basically between $6,500 and $8,000 per month. Again, depending on the facilities, the numbers that we see in the Jackson metro area are $7,000 to $7,500 typically. Okay. So it's very expensive. Somewhere between $75,000-$80,000 per year paying for that kind of care, which is why it's so critical to have a plan for doing that. Because there aren't many of us that in retirement have that kind of money coming in. And especially if we have someone else at home, we don't want all of the income going toward the care of the individual in the nursing home, leaving the at-home spouse completely destitute because they literally can't buy groceries. All their money's going to the nursing home cost.
Right. Okay. So who can qualify for Medicaid for nursing home care?
Well, it is a means-tested program, meaning if you have the means to pay for your own care, you don't qualify.
Okay.
If you are below certain financial limits, assets and income limits, then you do qualify. Now, the income limit, it changes every year. Currently, it's $2,349 per month as a monthly income. If your income is $1 more than that, so if you made $2,350, you're ineligible. You exceed the income limit.
Even a penny.
Even a penny, right? It exceeds the income limit for that. Now, that's a little bit of a red herring because there's an easy fix to that. But that is the technical limit as far as qualifying for Medicaid for institutional care. The limit that gets people is the asset limit. So there's an asset limit that if your assets exceed a certain level, you don't qualify. And for a Medicaid applicant, that asset limit is $4,000.
Okay.
Now, that's a really, obviously you think about the assets that you have, you hit $4,000 pretty fast as far as value. Now, fortunately, we don't count every single asset. There's some assets that are called exempt assets. The big exempt assets are a home worth, that's just under $600,000. I think the current number is $595,000. That's an exempt asset. Medicaid doesn't count that against you. An automobile, Medicaid doesn't count against you. Your household furnishings, they don't count against you. Funeral plot, they're not going to take your funeral plot away. You get to keep that because you're going to need it one day, right?
Right.
A prepaid funeral is exempt. Engagement rings exempt. There are little exemptions like that. But by and large, any other liquid assets that you have or things that could be converted to liquidity, like
Other jewelry?
other jewelry wouldn't be exempt. Yeah.
Okay.
Savings wouldn't be exempt. Certificates of deposit wouldn't be exempt. Annuities aren't exempt unless they fall in a really limited structure of having equal monthly payments and naming Medicaid as their beneficiary. So Medicaid's going to get the money. Are not exempt. So those are all countable. Land other than your house is a countable asset.
Okay.
And so not all land, the only land that has an exemption is your home, and that's only if you have an intent to return there. So those are the exempt assets. Those are some big things, obviously, that don't count against you. But if you got a $5,000 savings account, you don't qualify. You're rich, and so you'd have to spend $1,001 essentially to fall below that $4,000 limit and qualify for those Medicaid benefits.
Okay, and I think in that response you've just answered a lot of the next questions, maybe, but we'll try to get through them and make sure. You were just talking about qualification limits, and that's the next question. Are there any other qualification limits?
So you have to be aged, blind, or disabled. So basically 65 and older, or blind or disabled.
Okay, so earlier we were talking about in terms of monetary limits, right? And so now there are others.
Yeah, there are
These
other
physical
limits. You have to be lawfully in the United States. So the illegal aliens that we're worried about crossing the Mexican border can't cross over and then go on Medicaid, right? They don't have the lawful means of being here, so they're not qualified. Of course, people that are lawfully here, even if they're not U.S. citizens, can qualify for Medicaid benefits, but illegal aliens can't, or undocumented workers, I guess, depending on your political persuasion. So those are kind of some of the soft limits. You have to be a resident of Mississippi, so in order to get Medicaid under Mississippi rules. So if you move to Alabama, you're going to qualify under Alabama's Medicaid rules, which are different than Mississippi's rules. Every state has a Medicaid program. Every state's Medicaid program is run a little bit differently. They all receive federal dollars, so they have some similarities to them because there's some limits on what you can or can't count, how much money they can and can't have. But those limits are decided to some degree by the states within this range that the federal government allows us to have. And so there's a similarity but differences. So again, to qualify under Mississippi's division of Medicaid, you have to be a Mississippi resident, meaning residing here. Now, that doesn't mean you grew up here. So your mom could be living in Alabama, and you brought her over to Jackson, and then you put her in a nursing home here. She now is a Mississippi resident.
Okay.
So but you can't move move your mama to a facility in Pakistan and then you try to get them qualified for Medicaid, right? Because
Gotcha.
they used to be a Medicaid, so they're not a Mississippi resident at that point, even though the nursing home at Pakistan is probably a lot less expensive.
Okay. Next, if someone's income is greater than the limit, are they just out of luck?
Well, and I hinted at that, I guess. And so the answer to that is no, they're not out of luck. There's something called a qualified income trust. And a qualified income trust simply means that you can assign any income in excess of that limit that I told you, so that $2,349. Any income above that you assign to that trust, which can be only used to pay for your care or be used to reimburse the Division of Medicaid for anything that they're spending. So in other words, all your money above that has to go toward your care, but you're not out of luck just because you happen to have the misfortune of having $2,350 a month in income rather than $2,349 in income. Sometimes you'll hear that called a Miller Trust as well. Sometimes you'll hear it called a D4C Trust under the code provision that provides for it. They all mean the same thing, but it's basically a little 2-page document that says, hey, ignore any income that's above these limits. So income really should never keep anyone off of Medicaid. If they have too much, if they're making $4,000, they're about $1,500 of their money is going to go toward their care. Now they're deemed to have this $2,349 amount. And all of that money also, by the way, is going to go toward their care, except for $44 a month. And $44 a month is what they get to keep. Whether their income is $4,000 a month or $1,000 a month, they get $44 a month to go toward their personal needs allowance.
Okay.
Things that the nursing home won't pay for. Things that will provide extra comfort for them, hairbrushes or toothpaste or items of personal care that are not provided for by the facility. Now, obviously, $44 a month doesn't go very far. It won't get your hair done twice a month.
No.
May not get your hair cut once a month.
Some shampoo is $44.
But that's all that's all you get to keep. So that trust doesn't let you keep anything extra. All it does is get you qualified for the benefit that otherwise you'd be ineligible for.
Okay. All right. So the next question asks, does a spouse's income count?
So a spouse's income does not count. A spouse actually can make as much money as they make, and it has no impact on the institutionalized spouse's qualification for benefits. So if we've got one spouse that's still working and making $5,000 a month, they got a $60,000 a year job, and the spouse that is going to be institutionalized, the disabled spouse, let's say has Social Security benefits of $1,000 a month. Well, if not counting assets or anything, if that institutionalized spouse has to go to the nursing home, even though their combined income is certainly well above that $2,349 number I gave you, we only count the income of that institutionalized spouse. So that $1,000 is below $2,349. She would qualify for Medicaid, even though the at-home spouse would continue to earn $5,000. They're $60,000 a year. They're $5,000 per month salary.
Okay.
So it doesn't have to be $5,000 a month. It could be $20,000 a month. They could make $240,000 a year. Their spouse could still qualify for Medicaid because we count income separately.
Okay. If someone's assets are that's the same question twice. Okay.
No,
you already answered that.
That's an asset question.
Why? Okay. It sounds like the only option is to spend all of, I think they mean their money. Is that right?
So, I think what the questioner is asking is if someone is over-resourced. So we talked about income a second ago. The thing that keeps you off Medicaid is not the income. The thing that keeps you off Medicaid is the assets. If your assets are too high, you don't qualify. And the asset limit for the individual is $4,000. Now, fortunately, for a married spouse, the asset limit is a little bit higher. So basically, I think the current number is $128,640 is what the community spouse can have. So basically, round numbers, $128,000 of non-exempt assets, and their spouse could still be in the nursing home. So we don't have to get the family assets down below $4,000. We just have to get the applicant's assets below $4,000.
Okay.
And assets can be in excess of that, all the way up to $128,000 of non-exempt assets to qualify for benefits. So that's how the assets work. Now, unlike income, For assets, we count married couples' assets jointly.
Together,
right. Okay. So it doesn't matter if the assets are in the husband's name or wife's name or move them between them. There's no penalty moving them in between, and they count again. They count toward both of you, so it didn't really do any good, with the exception of that community spouse resource allowance, that $128,000 that you can put in the community spouse's name. So to get back into the question is, if say the family's got $50,000, husband and wife, and we move, the wife is going to go to the nursing home, and we move the $50,000 to the husband's name. So wife has zero, husband has $50,000, wife is qualified for Medicaid. Say in the same example, we have $228,000 of joint assets. Well, the wife can't qualify for Medicaid. If we put all that in the husband's name, we're $100,000 too much. We're above that limit by $100,000, and so we are rich under Medicaid's calculations. And so I think their question is then, this extra $100,000, what do we do? Can we do we have to give it away? Do we have to spend it? Right? And the answer is that it has to be made exempt in some fashion. Certainly, spending the money for something in exchange for fair market value would be a way of doing that, and the way they want you to spend it is on nursing home care, $7,000 a month, and after about a year and 3
then
months,
when you run out, you qualify, basically.
After that $100,000 is spent, then you qualify for benefits, right? So that's one use of that money. It's not the only use of that money. There are other things that we could do with those funds that Medicaid allows to be done and can qualify that for that individual. In my example with a husband and wife, we may take that extra $100,000 and purchase a special type of annuity, what's called a single premium immediate annuity, that would convert that $100,000 cash into an income stream for that individual. So by doing that, we got something in fair market value. We designed the annuity to meet Medicaid's law. They tell us this is how we want you to do an annuity, and if you do it this way, we won't count it against you. And now that spouse then can qualify for those benefits, and we've got some benefit from that. So there are things that we can do. We might go buy a really nice car, go shopping and get a nice Porsche or.
Well, they need a good car to travel to see the spouse in the nursing home.
That's right. So they can go in style in a $100,000 ride, right? So and a car is an exempt asset. So that's an example. We might do improvements to the house. We might buy a new house. With that type of money, we might upgrade the house to a more expensive house. So sell the house that we've got, add $100,000 to it. There are many things that we can do to then qualify for that individual for nursing care. Now, part of the difficulty in that is we don't really want to go spend $100,000 on a car.
No.
It's a depreciating asset, and it costs money to insure and all those things. The other problem with it is, if we got a spouse in the nursing home, we're going to need liquid funds. We're going to, and by putting them in a hard asset, whether it's a house or whether it's an automobile or whether it's something else, it's going to limit our ability to care for that individual in the nursing home, because we're not going to have direct access to those liquid funds anymore. We bought a hard exempt asset. Now, if you ask a person, well, would you rather the nursing home have this money or would you rather buy this Porsche? Probably they'd rather buy the Porsche, right? But all things being equal, if they have other choices, and they do, there are certainly things we can do to keep those assets in a liquid form that can be used and still qualify as an exemption for Medicaid purposes.
Okay. Now, I'm going to combine the next three questions because they seem very similar and they're along the lines of what you were just talking about. Okay. You're talking about spending the money. The next questions are about giving the money away. Okay. It says, why doesn't someone just give their money and assets away right before applying? And they're asking specifically about giving the assets to their spouse or to their children.
Oh, sure. And so that is people's knee-jerk reaction. Is in my example, I got $280,000. I got $228,000. I've got a spouse in the nursing home. I'm over-resourced as a married couple. We're over-resourced by $100,000.
Okay.
So the knee-jerk reaction is, let's just give the extra $100,000
to the kids,
And that's people's knee-jerk reaction. So the sad phone call that I get a couple times a year is where someone knows about this rule that I'm about to tell you. And the rule is, if you make a transfer of assets within 5 years of applying for Medicaid, you are disqualified for Medicaid benefits for a period of time based on the value of the assets that you transferred. Okay. And so it's what's called a 5-year look back. If you transfer them more than 5 years in advance, then there's no penalty. There's no adverse consequence to making that transfer of assets. People generally know that rule. They find out about it from hearing from people like me or from talking
We have
to
questions coming
their
up about
dresser.
5 years.
People know about the 5-year rule, right? And so one of the questioners asked about giving assets to the spouse. People misunderstand that a transfer between the spouse's assets are not counted together. And so in misapplying that rule, then they may take assets and move them from wife's name to husband's name, thinking that, well, now after 5 years are over, I fully protected those assets. Not knowing the rule that I just told you, which is we count married assets jointly. And so the transfer between husband and wife to husband doesn't do anything to make those assets disappear or to protect those assets in any way. And the saddest phone call I get is talking with someone, their spouse has been declining over the years, and they're about to place them in a nursing home, and they feel like they've done really good planning because they moved all the money from their spouse's name into their name, and so it's been more than 5 years, and they feel like they're about to qualify. They just wanted me to kind of confirm that. And the sad news I have to tell them is, well, for Medicaid purposes, that's all still your wife's money. Because we count assets jointly for married couples, so what's yours is hers and hers is yours for purposes of qualifying for Medicaid. Again, with that limited exception of that $128,000 community spouse resource allowance that we allow the at-home spouse to keep.
Okay.
So moving money between spouses doesn't help. It doesn't hurt either, by the way. There's no penalty for doing that, but it doesn't help doing it. The other knee-jerk reaction people have is, well, mom's going to the nursing home, let's take the money and give it to the kids. And unfortunately, because of that transfer penalty, that's a terrible plan. Unless it was done well in advance, it's going to disqualify that individual for qualifying for Medicaid benefits. With some very limited exceptions for transfer to a disabled child or something like that, it's going to disqualify them for some period of time.
Okay.
So.
All right. It's great that you can help people protect some of what they have saved, but it sounds like they still really lose a lot. Are there things people should think about doing in advance to protect their assets from Medicaid?
Well, there are, and if you wait, so I've mentioned to you some things we can do last minute. Frankly, people hear that 5-year rule and they say, oh, well, it's too late. There's nothing I can do. And that's simply not true. Mm-hmm. If we make a transfer of assets, there's a penalty, but the penalty doesn't mean that you're not still better off doing it. It's a math equation, right? And so we can figure out, we may be able to transfer some money, be penalized, and keep some money, because ultimately the goal would be to keep as much as the law allows us to keep, hopefully in liquid funds, so that we can take care of that individual in the spouse, mom, dad, a spouse, whoever that might be. Mm-hmm. However, except in some very limited circumstances, we are going to lose something in doing that. In a typical planning situation, I can usually keep or protect half to sometimes as much as 2/3 of the assets if someone's coming to me where someone's in the nursing home, yesterday or going in tomorrow. Mm-hmm. They come in with excess resources. We're going to lose some money. There's a number of factors that will determine that. Part of it is that 5-year look back. Part of it is what their other income is. Part of it is what the cost of the nursing home care is, and then other sources of income, perhaps like a long-term care policy or VA benefits that we've talked about on this show in the past. Right. So there's a number of things that go into the formula, but generally speaking, for most people that come in, I can save at least half, sometimes 2/3, occasionally 100%. Occasionally, wow, we're able to save all of the assets, and all can be a substantial amount of money. Mm-hmm. But in most cases, we're going to lose about half. So saving half sounds great. Losing half, though, sounds terrible. To get to this reader's question, there is planning that can and should be looked at being done in advance to avoid losing that half or losing that third of those assets that comes along with this at-need or crisis planning. And that would involve making a transfer of assets more than 60 months prior to needing that care. And so if the transfer is made more than 5 years in advance, the fact that we gave $1 million away has zero impact on mom's qualification for Medicaid, because we gave $1 million away 61 months ago. And when we filled out the Medicaid application, mom's in the nursing home, she's above 65 years old, she's disabled, her income is $3,000, her assets are zero because the $1 million that she used to have, we gave away 61 months ago. And we get to the question that says, have you made a transfer of assets in the last 5 years? And we just check the no box. Because those assets, that $1 million was given away 61 months ago. It's outside the 5-year look back. We now have protected $1 million. Mom's on Medicaid.
How convenient if you're planning to go in 5 years.
Well, that's right. So if you know when you're going in, you can do perfect planning, right? You figure out when that date is.
Those emergency cases where it's the sad phone call.
Yeah, and obviously no one's planning to go to the nursing home. I talk to groups all the time, and I'll ask them, if they're going to the nursing home, and unanimously, none of them are really planning on going to the nursing home. Now, statistically, 70% of people 65 and over are going to go to an extended care facility at some point during their lifetime. And so, if it's not, one of them, they need to look at the people to the left and right and give their condolences, because those two people are going to the nursing home. Right? No one's planning on that happening. The reality is it's going to happen to a lot of people, and it's going to happen more and more because science is going to keep us alive longer. And longer. And so it's not unusual now for us to have, coming through our office to do planning, send people that are over 100 years old. Right. And that's, we're seeing that more and more often, and I think we're going to continue to see that as modern science progresses to keep us alive longer. So for those that do want to plan ahead, the thing is, to look at is, should I look at transferring assets? Now, the knee jerk that they have in doing that is, well, I'm going to transfer it to my child. Right. That's who they think they're going to transfer these assets to. And for a number of reasons, that can be a terrible idea.
You're answering the next question.
Oh, well, tell me about it.
Sure. So earlier we had a question about asking, do I give my assets to the children? This one brings in the 5-year rule. They asked, should they just give everything to their children more than 5 years in advance?
So, and that does work. They can give it to the kids more 5 years in advance. Here are the reasons that we caution against that. Is first and foremost, if you give assets to your children, they're no longer yours. They belong to your children. And so then if the child goes out and buys that Porsche that you managed to make your whole life without having to buy it, there's really nothing you can say about it.
Or make bad business decisions that affect their assets, or the spouse is not as trustworthy, maybe.
Yeah, I mean, all sorts of terrible things can happen if we give these assets to kids. They may take it as an early inheritance. They may start taking trips and things like that. They may be, good children and not misspend money, but that money's sitting there and mom's not going to need it. I'm just going to borrow a little bit of it. We're a little short this month. I'm going to pay it back.
Put it back.
And I'm going to borrow a little the next month and such. And then if mom later on does need it, that money's not there. It's also not there to split between the other siblings because we borrowed that money against it. And we do and have seen things like that. The other thing, you may say, well, my son's a good boy. He would never do that, right? Right. Well, is it possible that your son could predecease you? Because if you give that $1 million to your child more than 5 years in advance and he dies, it's obviously no longer his money. Right. And so your son loves you, you love your son. How do you feel about the daughter-in-law? Because that may be where the money went, or she died in a terrible car wreck with him, and now it's in a guardianship for the child or your grandchildren, and you can never have access to it, even regardless of need, because it wasn't yours. You gave it away. And so for those reasons, it's kind of a scary thing to do. There are also things that can take that money from a child, things like a bad business deal, like you mentioned. I mean, we went, it's only been a decade when we went through the Great Recession. Oh, yeah. And there were lots of people that had really good businesses that failed because of economic circumstances that they had zero control of. And those things can and will happen again. And so a bad business decision that they make, a bad business climate that they're unable now to survive in, may result in a bankruptcy. Their creditors can go after all of their money, including the money that mom gave the son or daughter. And so there's a terrible risk that you put in place just by transferring those assets. You may be thinking that you're protecting it, only to find that you're losing it because you're adding extra risk to things that are otherwise there. So we really encourage people to think heavily before actually making a transfer, even though it seems like a really simple thing to do. You're also costing yourself taxes in many cases, and many times also costing your children taxes by doing that. And here's the reason why, because the main asset that most people think about giving in this circumstance is their what? Their home.
Right.
That's the call that we get is I've worked, I've paid for the home, I don't want to lose the home to Medicaid. And so if we give that home to a child, the phone call that I get the following year is, oh my gosh, I got my tax bill in the mail.
Oh.
And the taxes just went up $2,000 because we just lost homestead exemption. And so, because it's your home, you qualify for homestead exemption. When you give your home to your child, it's not their home anymore.
Right.
It's not your home. That's the one living there. They're not living there, so it's not homestead exempt for them. Suddenly, that exemption goes away, and the taxes immediately go up, and they are up the next year, and the next year, and the next year. And so that transfer and saving that money is going to cost sometimes tens of thousands of dollars over the course of that lifetime. The other tax that you may be costing children is the loss of something called stepped-up basis.
Okay.
So stepped-up basis refers to the magic that occurs at death. There are a few gifts in the tax code. We think of the tax code as being a terrible thing and it takes our money every April 15th and such, but there are a few gifts in it. And one of those gifts is something called stepped-up basis on inherited assets, where if you inherit something from your parents or from your great aunt or something like that, that your basis in that property, your cost basis, is fair market value on the date of death. And the reason that becomes important is because basis determines income. If I buy a house for $100,000 and then I sell that house 10 years later for $200,000, I've just made profit of how much?
You tell me.
Math.
You're the expert.
$100,000 profit. Right. I bought it for $100,000. I sold it for $200,000. I made $100,000 profit. We call that profit capital gains.
Okay.
Capital gains is subject to income taxes of somewhere between 15 and 20% income tax rate. So that $100,000, I might have just lost $20,000. If my mom has this property, they bought it at $100,000, and now it's worth $200,000, she gives it to me. More than 5 years in advance, thinking that she's going to trying to protect these assets from Medicaid, right? Then she passes away, and I then sell the house for $200,000. I have to pay that same $20,000 gain because my basis in that example is a transferred basis. I have her basis in the property. Her basis was $100,000. My basis is $100,000. We then sell the property for $200,000, or I sell the property for $200,000. I've got a gain. If I inherit that property from my parent, then I get a stepped-up basis at the time of inheritance. So I sell it for $200,000. Even though she paid $100,000, I inherit it. I sell it for $200,000. I pay zero tax. I just saved $20,000 in that example. And if the house is not very old, there's probably not much gain in it. But in a lot of these cases, Mom and Dad bought this house. Might have been their first house even. They've worked and paid it off, and they bought it
Maybe
at a very low rate.
more than 50 years ago.
Been there for 30, 40, 50 years. Values have gone up, especially if this is property that was in rural Madison, that now is in Madison County.
Right.
That property value has gone up dramatically. And so that trapped tax is either going to fall onto the shoulders of the children, or we can use the gift in the tax code to make it go away. But if you give the property just to the child, like I said, you may be losing out on homestead exemption, and you're probably costing that child some taxes. So for all of those reasons, even though, 5 years in advance, we could make a gift to the child, it's simple and such as that, in most cases, it's a bad idea, even when it's an only child. Even when it's an only child, because, again, those same bad things can happen in those circumstances. And why are we costing our child taxes, that we could have avoided? Child's going to be better off. We're going to be better off having done that. Sure. The way that we encourage people to look at doing this is, instead of making an outright gift more than 5 years in advance, look at doing a trust. And there's a special type of trust that you can create. It's called a legacy trust, where you move those assets into that trust and start that 5-year clock running. Now, the beauty of that is, by moving into that trust, you can retain control. You can be the trustee. Mom can transfer her $1 million and her home into that trust and make herself the trustee of that trust. Those 5 years start running. If 6 years pass, 7 years pass, Mom has to go to a nursing home. Those assets are still in that trust, Up to her incapacity, mom was trustee. Upon her incapacity, her son becomes the trustee, let's just say.
Okay.
But she's retained control over those assets. She can retain control not only of the management of them, but how they're invested. She can retain control of distributions of those assets. She can even retain the control of the power of inheritance, meaning she can retain the power to say who gets those assets when she dies, and she can change her mind about it all the way up to the time that she passes. She's not really giving up any of the major controls over those assets, but she is giving up just enough to start that 5-year clock running for Medicaid purposes.
Okay.
So that we think is a better approach, because if in my example there, we gave away a house and $1 million, I retained the right to reside in the home. The tax bill comes the next year, homestead exemption is still on there.
Okay.
Next year, still get homestead exemption. So we haven't lost anything. But by retention of those powers, whenever I do die, then that child receives that property from that trust. They got a stepped up basis in that property. And so that property that I paid $100,000 for, that's now worth $200,000 at the time of my death, it costs nobody anything except the IRS doesn't collect that $20,000. And so it saves taxes for the recipient by doing that in that trust.
All right.
The third thing about it is, by not only do we retain control of it, but if we do have a horrible event like the death of a child, or have a terrible event like a economic catastrophe where the child gets sued, maybe a lawsuit from a car wreck, maybe a lawsuit from a bad business deal or a bank loan or a tax lien or any number of things that could happen to that individual, that child's money may be completely wiped out as a result of their bankruptcy or their insolvency and such, but the money in that trust is not their asset. It doesn't belong to them, it's a trust. And so those assets are protected from those outside threats. And so even death doesn't result in taking those assets from it. It's not going to go to the daughter-in-law, in other words.
Yeah.
And so we're able to basically retain control, retain protection of those assets, and yet start that 5-year clock running. So if the unthinkable does happen, and we do have to go to an assisted a facility, a long-term care facility, we're not going to be penniless there. In other words, those assets will be there and be fully protected for you, and more importantly, perhaps for family members, so that you are able to leave a legacy, leave an inheritance for the next generations or so.
Okay.
So that's a better approach, we think, than the what the person asked. The long answer, I suppose. But the question of should I give it to my kids? You can, but it's probably a bad idea,
Gotcha.
at least compared to the much better idea of putting it into a legacy trust.
Makes sense. Yes. Marianne Hollis and Debbie Humble, they've had great discussion and good information, so thank you for that. We have just a few minutes, so I think if we can quickly, let's get this last one in here. It says, if my mother is already in a nursing home, we are paying privately, is it too late to protect any of her assets?
You know, Kelly, that's one of the saddest things that people misunderstand. They know about this 5-year rule that's out there, and they think, oh well, it's too late. We've already entered the nursing home, and so I can't really do anything. It's never too late. If you've got assets, I've already told you I can protect at least half of them, and I say federal law allows us to protect at least half of them. Sometimes 2/3, sometimes occasionally all of them. We just have to use the law that's there, apply what Congress puts in place, and the fact that you've already entered the nursing home, the fact that you've already started privately paying, the fact that you may have even applied for Medicaid and been denied, doesn't mean that you can't do this planning. We then simply go in place, start doing that planning, and upon once things are put in place, once we've moved the assets, recharacterized the assets, done the things that federal law allows us to do, we can then qualify for those benefits. We're probably going to lose some assets along the way, but again, if we can preserve anything, it's going to be much better than being destitute, having less than $4,000 and get to keep $44 a month.
And they're already privately paying, so they're already reducing those assets.
They're reducing very rapidly, yeah.
Very rapidly at $7,500 a month there.
The sad call I get a lot of times is someone that says, we got to do something. We're down to $40,000, and I say, okay, well, I can probably protect most of that in that particular case.
In this scenario, they just need to give you a call at 601 Elder Law, right?
They can call 601 Elder Law, yeah. And find out, we can give you a 15-minute call and let you know, are you a good candidate for doing this type of thing. But the call that I get there is, I'm down to my last $40,000. We're going to be out of money in 6 months. What can we do?
Okay.
And we'll say, well, there are things we can do, but you say you're out of money. How long have you been doing this? Oh, we've been paying for the last 6 years. We started out with $600,000, and Had we had this conversation 6 years ago, I couldn't have saved $20,000 for them. I could have saved about $400,000 for them. But they thought that they went to the nursing home and started paying, that was all that they could do. And in fact, that's never the rule. If you've got some assets, there's something we can do. Law allows us to put some things in place to protect those assets. There's public policy in place for that. We simply have to apply what Congress has put, as made available to us to do to benefit.
All right. Oh, we have a question on Facebook from Lee. Says, my best friend's 12-year-old daughter has cancer and cannot get Medicaid. Do you know why? Which this isn't about nursing home, though.
Yeah, it's outside.
It's a little bit different.
There are multiple Medicaid programs. So it's, whenever we say Medicaid, I'm really talking about a specific Medicaid program of people aged, blind, or disabled, institutionalized in a facility and making less than 3 times the poverty limit. That's the specific program that I'm talking about here. I'm not an expert, unfortunately, in all the Medicaid programs, and certainly not the ones that deal with children. I do know there are some issues going on just from reading in the newspaper and things about that program, and so I see some of the sad results about this. Unfortunately, that's outside of my level of expertise. I wish I could help you, but I can't.
Yes, you're in elder law and nursing home.
Yeah, I'm on other end of the spectrum, not the 12-year-old, but the
112-year-old.
112-year-old, perhaps. I could help. Yeah.
So we just mentioned your phone number, how they can get in touch with you, 601 Elder Law. Tell your viewers our website real quick before we close.
Website is www.mortonelderlaw.com. And so a lot of free resources on there, a lot of videos, a lot of free reports, things of that nature. Also, if you're interested in this, this information, got 2 good resources that viewers on here are free to get. Call the office at 601 Elder Law, and they'll be glad to send it to you. Or text the word Dixie. That's for the Dixie book. Well, wrong one. Dixie book over here. Text the word Dixie to 601-600-2662. And that's just a text number. You just if you got to put the word Dixie in there. I won't know what you're wanting.
And those numbers are in the comments too. So if you miss that,
right, they're in the comments. Yeah. Right. So if you'll text the word Dixie there, it'll give you immediate access to an electronic copy of that book, and it'll give you the ability to order that, so we can send you a hard copy. But I'd love to do that. Again, we're down to a few, the last dozen or so of these. So if you really want one of these, give us a call, because we'd love to provide that to you. But anybody that has those type issues, call the office. We'll be happy to have a 15-minute call with anybody. And the purpose of that call, we're not going to solve a problem, by the way, in 15 minutes.
15 minutes.
This is complicated stuff.
Sure.
But what we are going to be able to do is identify, do you have the type of problem that we can provide a solution for? It may be that, no, you're fine. You could go ahead and apply for Medicaid. You already qualify. It may be this is not the type of problem like the person with the 12-year-old child on cancer, not the thing we handle. But if it's an area that we think we can be of assistance, we can then set you up for an in-person hour or so consult where we can really talk through in detail and talk through what your goals are, what the desires are, what the assets are, and what we might do, whether it's pre-planning to get those assets moved out of at risk more than 60 months in advance, or whether it is a crisis case, an at-need case, where someone's already in the nursing home and they're burning through money at $8,000 a month, and we don't want to leave mom destitute as a result of that. Because let's face it, federal law allows us to keep $128,000, but that's not really a lot of money whenever you plan for retirement. And we don't want to leave a destitute spouse with just $128,000 if we can provide significantly more. And the law allows us to provide significantly more if we simply take the steps to do that and follow those rules.
All right. It's been a pleasure. Thank you so much for coming in today and giving us all this.
Thanks.
We wouldn't know about this nursing home stuff because we don't think about it at this age and time frame, but it's something to definitely know about. And I'm glad that you came on, and now I know what to do, because
Great.
I have parents too. So we all do.
Most of this work, especially on the crisis side, is the children coming in for this, and so we have a lot of the parents will come in and do the pre-planning.
Right.
But when we're talking about crisis
Falls
planning,
on the adult
it really does
children.
fall on the adult children.
Right,
so
right.
That's,
Okay. Well, again, thank you very
Thank
much.
you.
I thank you all for watching. We will be back next week, so send your questions to the Ask Experts page on WLBT.com. You all enjoy your weekend.